Immigration Courts vs. USCIS Crackdown, August 2025 Reality Check. Immigration in America is standing at a sharp crossroads. While courts are delivering some of the biggest victories immigrant families have seen in years, USCIS is introducing rules that could fundamentally reshape the path to approval. Today, we break it all down: the wins, the risks, and why every immigrant needs to pay attention now. The courts push back. Major wins in 2025. Let's start with the good news because, for many families, these rulings are nothing short of life-changing. In California, the Ninth Circuit Court of Appeals stopped unlawful workplace raids. Agents can no longer detain people based on appearance or where they work. For years, thousands feared sudden arrests. This ruling reminds us that constitutional protections apply to everyone, regardless of immigration status. Next, birthright citizenship, a core principle of American law, was under attack through an executive order. Courts struck it down, reaffirming that children born on U.S. soil remain U.S. citizens under the 14th Amendment. For immigrant parents, this wasn't just legal jargon, it was relief from the fear that their kids might be rendered stateless. Another massive intervention? Plans for mass detentions. Earlier this summer, reports suggested ICE aimed to detain thousands per day. Communities braced for raids, but courts stepped in, stopping large-scale detention efforts before they could begin. For families, this meant stability. Kids didn't come home to empty houses, and workplaces weren't gutted overnight. Humanitarian parole also survived a major legal challenge. Over 500,000 migrants from countries like Cuba, Haiti, Venezuela, and Nicaragua rely on this program for safety. Courts preserved it, keeping doors open for those fleeing crisis. Judges also restored bond rights in removal proceedings, giving detainees a chance to reunite with families while fighting their cases. These victories signal a strong judicial check on overreach. USCIS strikes back, the anti-Americanism rule. But here's where the story shifts. While the courts protect, USCIS has rolled out one of the most controversial rules in years, the so-called anti-Americanism policy. Starting this month, officers can deny visas, green cards, or naturalization applications if they believe an applicant supports anti-American views. Sounds straightforward? It's not. The problem is anti-American isn't defined in immigration law. This gives officers enormous discretion. Something as simple as an old social media post criticizing U.S. policy could trigger questions or even denial. Immigration lawyers warn that free speech might now be confused with disloyalty. USCIS says it will look at online activity, affiliations, and even past associations for signs of extremism or anti-Semitic beliefs. Supporters argue this protects national security. Critics see a slippery slope where opinion becomes grounds for rejection. And because there's no clear standard, outcomes can vary wildly from one officer to another. Why this matters more than ever? Here's the reality. Immigrants today face a system pulling in two directions. Courts are shielding rights, but USCIS controls applications, and their discretion is growing. Every detail matters now. Small mistakes, controversial opinions, or incomplete documentation could derail a case entirely. This is where preparation becomes critical. Immigration isn't just about staying out of trouble anymore, it's about proactive strategy. Applicants need to review their online history, collect evidence of positive community contributions, and, when possible, seek legal guidance. The margin of error is shrinking fast. I recently spoke with an attorney who handles complex immigration cases. They shared a trend that's becoming more common: cases delayed for months over something as small as a 10-year-old Facebook comment. What used to be a straightforward review now involves digital audits and ideological screening. This isn't hypothetical, it's happening. And it's why applicants need to think beyond forms and fees. Reputation management has become part of the process. Final takeaway. August 2025 shows us two truths. Courts are still powerful protectors, blocking raids, defending birthright citizenship, and preserving humanitarian programs. But USCIS is rewriting the playbook, introducing subjective rules that make every application more vulnerable. For immigrant families, the message is clear. Awareness, preparation, and documentation are not optional. They are survival tools. If you found this update helpful, don't forget to like, subscribe, and hit the bell for more critical immigration updates. This is Visa Intel USA, where we keep you informed, prepared, and ahead of the curve. Thanks for watching, and see you in the next video.